Thank you again for joining our webinar today, What to Do Before a Loved One Passes. My name is Kelly Blount, and I'm the Program Marketing Specialist here at General Electric Credit Union. We're so glad you've joined us as we have a lot of great content ahead. Thanks to technology, we're excited to be able to connect with you on such a great topic and wanted to thank you all for tuning in from the comfort of your home, work, or wherever you may be today. And with that, I'm going to turn this over to our guest speakers today, Lauren Dunbar and Bridget Cotton from the Credit Union, to take us through today's topic.
Good afternoon. Thank you, Kelly. My name is Lauren Dunbar. I am the Vice President of Business Development here at General Electric Credit Union. I have been with the credit union for about 3 years and in the financial services industry for almost 8. So now I'm going to turn it over to Bridget.
Good afternoon. My name is Bridget Cotton, and I'm a specialized account representative with the credit union. I've been with General Electric Credit Union for almost a year, but have over 20 years of customer service experience. So before we get started today, we're actually going to share a couple stories with you. The first story is Daniel's story. So Daniel and Barbara have been married for 20 years and have 2 children. While they were walking along a beach one day, Barbara collapsed. She was rushed to the hospital to be evaluated. Based upon her condition, the doctor decides to place Barbara into a medically induced coma. Her prognosis is uncertain, so the doctor advises Daniel to start preparing for the inevitable. Barbara, like many members of families, is responsible for handling the financial matters like paying bills, etc. So Daniel has no clue what needs to be done, where things are, and he doesn't even know where Barbara keeps all the important paperwork. Not to mention, he's trying to deal with his own emotions and emotions of his children because they're worried, about their mom and his wife. So you can imagine how much stress and distress this causes Daniel. So our next story is Jackie's story. Now, Jackie's a widower and she lives by herself. While walking to the mailbox, she slips in her driveway and spent months in the hospital before being moved to a rehabilitation center. She has 2 adult children, but neither of them live close. So this story, as you can imagine, is probably similar to a lot of people. However, because they are able to manage her financial matters while she's in a hospital and in the rehabilitation center, it makes it much easier for things to be taken care of for Jackie. After their father, who was primarily responsible for financial matters, passed away, her children knew that they needed to take care of things for their mom. And so they put plans in place so that if anything would ever happen to Jackie, they would be able to take care of it for her, especially because they don't live close. So why do we share these stories with you? If you look at the past 2 years, or maybe almost 2.5 years now with the pandemic, that has totally caught most of us off guard. And we weren't prepared for what followed, with things being shut down and not being able to go out and do things. So these are the types of events, although we would have never expected pandemic things like that to happen, those are things we need to be prepared for, because it could just be an emergency like Jackie's story where she got hurt, or it could be a traumatic event like Daniel's story where his wife may end up passing away. So in today's session, here are the topics that we are going to cover. Important paperwork and records. Specifically, we'll talk about personal records and financial, power of attorney, ownership of deposit accounts, trust, beneficiaries, and accounts to consider added beneficiaries too. So the first topic we are going to cover is important paperwork and records. So important paperwork and records could be different depending on the family or the person. 2 specific things that we want to talk about are personal and financial. So what does it mean to get your important paperwork and records together? It just means arranging that paperwork so that when your family needs to take action, regardless of whether or not it's just an emergency event or a person may pass away, they can get to those records easily and quickly, so that they can go ahead and get the process started. If that is just arranging medical care or if that's arranging a funeral. So you can imagine for many families, it's overwhelming. And if this is done in advance, then it makes that process much easier. So as just a recommendation, it's important that you review these documents annually or however often you want to review them. But most people we find might find it easier if they would just review it around tax time, since that is an event that happens every year. So on the next slide, we're going to talk about personal records. So again, what you determine to be personal or financial is totally up to you. What we're going over today is just a guide. So some personal records could be birth certificate, social security card. Those two things are ways that you can be identified or identification of you. Your marriage certificate, your divorce decree, those are going to be important because if there is information in that divorce decree that says these are things you're specifically responsible for or your ex-spouse is responsible for, those things would be able to be identified. Names and addresses of your children and or other family member, those are going to be important contacts so that if there is an emergency, whoever is going to assist with these matters knows who to contact. Names and phone numbers of close friends, relatives, doctors, lawyers, and financial advisors. Those contacts are also important because if your doctor needs to be notified, you have an attorney that needs to be notified, financial advisors because of those legal matters, then it's much easier for someone to get in contact with them. So kind of imagine if something did happen and you had no clue who to contact. You're going to be taking time to have to go through many, papers, documents, trying to assess who needs to be called, when they need to be called. But if the information is contained in your personal records, much quicker to get to. Employer information, that's going to be important because your employer may need to be notified of an emergency or in the event of a passing. Education and military records, again, important. If you served in the military, it may be necessary for that branch of service to be contacted. So on the next slide, we have financial records. So some of those things are names of your banks and account numbers. So not only would I say include the names and banks of account numbers, but it's also important that if you have bill pay set up through the banks, that you also include what gets paid, when it gets paid, and how much is paid. Unfortunately, there are many families who don't have that information and sometimes don't know where to start, what needs to be paid, if something has already been paid, and if money is already coming out of the account or should be coming out of their accounts. So that's good information to include, not only the name of the bank and the account numbers, but bill pays. And also if you have maybe a personal banker that you work with, might be important to include there. Sources of income, so your pensions, IRAs, 401ks, your Social Security and Medicare to Medicaid information, insurance information like life, health, long-term care, home, your car insurance. Again, if it's an emergency and you might have some long-term care information, and if we have that information as a family member, then we know who to contact and get things set up. Copies of your most recent income tax return, location of your most up-to-date will and or trust with an original signature, mortgages and other liabilities, including property tax, what is owed to whom, when payments are due. Again, it's important to keep on top of things, especially when it comes to like a mortgage payment, making sure that the mortgage payment is still made on time so you don't run into an issue with the mortgage being past due or whatever debt there may be out there being past due, so that you can keep on top of things. Location of the original deed for your home, car titles and registrations, location of safe deposit box and keys, One thing I'd like to say about that is there's often times where keys can't be found. And so there could be a cost associated with having to get keys duplicated or to drill into a safe deposit box in order to find out what the contents are. So not only would you want the location of the safe deposit box and keys, but you would also want a list of what's in the safe deposit box. You know, I've had some families who were looking for important documents and believe that their family member actually had it in the safe deposit box, but they couldn't find the keys. And they weren't even sure. So having that information together would be helpful so that, again, you're not spending a lot of time trying to search for those records and for the documents that may be necessary for you to have. Again, going to remind you, it's just important that when you do put these documents together, however you decide to classify them, that you do a periodic review of the documents so that you can make sure that they're kept up to date and changes get made if they're needed. So on the next slide, we're actually going to walk through steps to getting your ducks in a row. So again, these are just a guide. Whatever you feel is appropriate for you to do, that's what we would say to do. But there are two reasons I'd like to share that I think it's important to get your ducks in a row. The first one is for you, and the other is for your family. Again, for you, you will feel relieved that things are prepared so that you're not having to worry about, let's say you want to go on vacation, and while you're on vacation, something happens and you don't have things prepared where if your family has to step in and take matters into their hands, that they're going to have to be scrambling trying to find information. The other one is that your family will save a lot of time trying to find documents. You know, having your affairs in order is really important, having things organized so that when your family has to do something, that it's in one location for them to be able to find it. So some of the steps would include place your important papers and copies of your legal documents in one place. That could be a filing cabinet, it could be a safe, it could be a notebook, but whatever you decide to do, just having them in one location is going to be important. Advise a family, trusted family member or friend where you keep those paperwork or legal documents. So that, again, when something happens, whether it's an emergency or a person has passed away, they know exactly where to go find it, and you've already advised someone that where the documents are located. Speak with your named fiduciaries about the details of their role. So it's important that if someone is listed as the executor, they know what you're expecting to happen after you pass away or in the event of emergency. If they're not aware that they're even named the executor or the person that's designated to help with your matters, then they'll have no clue what they're supposed to be doing or that they're even supposed to do it. And you also want to make sure that they're okay with it, because not everybody can handle what it takes to take care of someone's financial or personal matters after they've passed away or when there's an emergency. So you want to make sure whoever you've designated to be that person is someone that they're willing to do it and capable of handling it. Periodically review estate planning documents to ensure they reflect your wishes. You know, things can change. You may want to designate all of your funds to go to, let's say, a charitable organization, but then something happens and you decide that you need to switch it up and maybe you're going to designate it to go to one person. But if you fail to go back and look at those documents and make sure that it reflects what you want, then whatever is last on that document is what's going to happen. Discuss your wishes for end of life care, and that's going to be important just so that the person that is responsible for your estate, whether or not it's the executor or if it's a family member, they know exactly what you want to happen. You know, in the event that you are in the hospital, if we think about, again, the pandemic and a lot of people were placed on respirators and things like that, and that may not be something that you want. So that needs to be reflected, and you need to make sure that whoever is designated knows what you want. Address the disposition of tangible and personal property, art, jewelry, furniture. Again, if you want it donated, then that needs to be, you need to make sure that that's addressed. If you want it to be given to family, then you need to list specifically who's to receive it and what to receive. That's where a will definitely come in place and make sure that everything that you want to happen is addressed in there.
On the next slide, we are going to talk about some terminology. I'm going to briefly go over the definitions, and a lot of these on later slides we go into quite a bit of detail about. So power of attorney is an authorization that gives an individual that is called the agent the power to act for another person known as the principal. It is important to remember that powers of attorney are only valid if the principal is still living. We will, on the next slide, we're going to talk a lot about power of attorney and a little more detail about what that means. As Bridget alluded to, a will is the legal document that spells out a person's wishes regarding the distribution of assets after death. Probate, which we hear about often, and I think that people think that is a scary word, but probate is the process in which a will is reviewed to determine whether it is valid and authentic. And probate then refers to the administration of a deceased individual's will or the estate of a deceased person without a will. So we'll talk about that a little bit later as well. An estate is the total of all assets someone owns and all liabilities they owe at the time of their death. An executor, which is sometimes also referred to as a commissioner or an administrator, is an individual appointed to administer the will or estate of a deceased person. A trustee is a person who acts as a custodian for the assets held within a trust. And we're going to talk about trust quite a bit in a few slides from now. A successor trustee is the person responsible for acting as a custodian for the assets held within a trust after an appointed trustee passes away or resigns. And a grantor is an individual or other entity who creates a trust. So that was some dry definition for you. So I appreciate you giving me the opportunity to run through those, but now we're going to put a lot of that into context here. So as I stated, a power of attorney is the legal authorization that gives a person who is the agent the power to act for another person who is the principal. So if you execute a power of attorney, you are the principal and you are giving somebody the ability to act on your behalf. Once again, it's important to remember that powers of attorney are only valid if the principal is still living. Oftentimes in our department, we do see individuals who have passed away and their power of attorney will provide us the power of attorney paperwork. And unfortunately, that power of attorney does cease to be valid once that principal has passed away. There are power of attorney laws in every state. Just for example, in Ohio, anyone can be a power of attorney as long as they're 18, of sound mind, and can properly execute the power of attorney. And there are many, many different kinds of powers of attorney. So I wanted to go over a little bit about what those meant and at least what it means to us and what we would need to see in the financial industry to be able to have somebody act as power of attorney on your account. So on the next slide, we go into some of those definitions. A limited power of attorney gives the agent the power to act on behalf of the principal in specific matters or events. And this can really be anything. We've seen them written all sorts of different ways, but just as a quick example, it might state the power of attorney is only effective for a certain time period or after a certain event occurs. There is another word that you might have heard in regard to power of attorney, which is a durable power of attorney. That means that the agent can act whether or not the principal is disabled. So sometimes power of attorneys, once they're executed, are enforceable right away, and sometimes they're not. So if they're durable, most of the time that means they're enforceable right away. Sometimes when they're limited, we have to wait. We cannot use them unless a certain event has happened, or if the principal is in fact disabled or cannot act on their own. And then I wanted to make sure we discussed the difference between financial power of attorney and healthcare power of attorney, because I do think that that causes some confusion. So those are different documents. Healthcare power of attorney specifically gives the agent the power to make health-related decisions. It's very involved in what decisions can be made, what decisions cannot be made, and things of that nature, but it really does focus on medical and healthcare only. We oftentimes, again, in our department, see people provide us with healthcare powers of attorney, and that unfortunately does not give any indication on whether finances can be handled for an individual. So what we as a financial institution or any other financial institution would be looking for in order to process a power of attorney would be a financial power of attorney, which would give the agent the power to manage the business, financial affairs for the principal, such as signing checks, opening new accounts, obtaining loans if needed, managing investment accounts, accessing a safety deposit box, as Bridget talked about before. So that is specifically the financial power of attorney that we would be looking for. I also want to make sure that I note here, because there might be some people on this call who do have a trust, or you are trustee on a trust. It's important to remember that power of attorney and trust, they're both legal documents, and powers of attorney generally only give the agent the power to act on behalf of consumer accounts. So you would want to consult your attorney if you do have trust accounts, to ensure that if you would like your power of attorney to act as your role as a trustee, that both documents reflect that appropriately. On the next slide, we're going to talk a little bit about ownership of deposit accounts. So there's multiple different ways on your bank accounts here at the credit union or any other financial institution that you might have, that your accounts can be titled. So we're going to talk about a little bit how they're titled, and a little bit about maybe how they could or should be titled to help you plan for the events that Bridget was talking about. So on sole owned accounts, it means exactly as it sounds. There's no joint owner, and there's no listed beneficiaries. Ultimately, if on a sole owned account, if that individual, that sole owner, passes away, those accounts will go through probate. And it would be necessary to assign an individual the role of the executor for them to manage the estate and figure out how those funds should be distributed. Joint owned accounts are, that's exactly it. There's at least 2 owners on the account. There can be more. Sometimes we see 3 or 4 owners on an account. Most of the time we see 2 owners on an account. And if one of those owners passes away, the funds would be issued to the other living joint owner. And that would not be a case where that account would need to go through probate if something were to happen. Accounts with beneficiaries. If it's a sole owned account, but there are listed beneficiaries, again, that account would not have to go through the probate court. As long as those beneficiaries are living, the funds would be distributed to the beneficiaries. And then of course there's trust accounts that generally if the grantor is living, it's under their social security number. And when that grantor passes away, which we'll talk about here in a little bit, more detail of what that means, then the trust will likely need to be converted to an EIN trust. So on the next slide, we are going to talk about trust accounts. And I think it's also important to remember that both on powers of attorney and on trust. So if you have the role of a power of attorney or you have the role of a trustee, whether it is your trust or you're helping manage someone else's trust, that this is a fiduciary responsibility. So the power of attorney has a fiduciary responsibility to act in the best interests of the principal, just like a trustee has a fiduciary responsibility to act exactly as the grantor has listed in that document. So a trust specifically, there's 3 parties to a trust. Sometimes they're the same people, sometimes they're not. So the person or people who create a trust, those are termed the grantor. Those individuals, the grantor, really own the funds of the trust while they're living the majority of the time. They own the funds and they give the trustee the power to transact or hold the property. Most of the time, if it's a revocable trust, which we'll talk about, the grantor and the trustee are likely the same people. You might have the Lauren Dunbar Living Trust, and I am the grantor, and I also appoint myself as trustee to manage my own trust while I'm living. That's the most common situation we see. The third party to a trust is the beneficiary. So ultimately, in the Lauren Dunbar Family Trust, where I am the grantor and the trustee, at some point, if I pass away, there will be information on who is going to benefit from the assets within that trust, and that is in fact the beneficiary. So we talked about revocable trusts, and revocable trusts can be amended or revoked during someone's lifetime. So if I execute a revocable trust, I can decide that I want to revoke that trust, resolve that trust. Maybe I've decided that I want to title my accounts a different way, and I can do that under a revocable trust. That is different from an irrevocable trust, and that is a trust that cannot be changed or canceled after the document has been signed. Most of the time, you will see a situation, just like in my example, where I am the grantor of the Lauren Dunbar Trust, and I am the trustee, and that would be a revocable trust most of the time. And if I pass away, that then becomes an irrevocable trust that can no longer be changed, and the trust assets have to be distributed as written in the trust. When something happens to the trustee, so in my situation, if I am the grantor and the trustee, if I pass away, likely written in that document, there will be called what's termed a successor trustee, who is the person that will become the trustee and start having control over the assets of that trust when the original trustee has passed away. And now I'm going to pass it over to Bridget to talk about beneficiaries.
So having a beneficiary named on your assets is really important. Again, Lauren had said that if we don't, then those assets would have to be probated. So to keep your family from having to start that process or even go through that process, it's important to have beneficiaries assigned. So the beneficiary would be the person who's going to benefit from an event, a trust, a will, or an action. So when we think about the types of accounts that Lauren went over, again, if it's a sole owned account that has a beneficiary, then that beneficiary is going to benefit from the funds that are in those accounts. So a couple of terms that maybe get used. One is payable on death and transfer on death. So the first one I'm going to talk about is payable on death. That's actually the event. That's not the beneficiary. So that's the event or the arrangement that is made for the beneficiary to be designated. Transfer on death is similar, but it's not with accounts, your deposit accounts here at the credit union. So at the credit union, we would have beneficiaries. The act to add the beneficiary is called payable on debt. Payable on death. Where you'll see transfer on death is usually with brokerage accounts, stocks, bonds, titled assets. And in some cases, when you do have beneficiaries, you could actually have different types of beneficiaries. The first one would be who's the primary person that's going to receive the funds, or is the person that's going to be benefiting from being named the beneficiary. So in cases like an IRA and life insurance, you could have a primary beneficiary, and that primary beneficiary could actually then be designated to receive a certain amount. So you might want to have 4 beneficiaries, and each person may be designated to get a certain percentage. So maybe you want the first person to get 50% and all the other beneficiaries then get the remaining amount that would equal up to 100%. In the event that those beneficiaries could pass away, you could also have contingent beneficiaries. So you could have one primary, as an example, and then one contingent, so that if that primary beneficiary passes away, there would already be someone designated to then replace that primary beneficiary. So they would be, the contingent would be the next person in line to receive the asset that they were named beneficiary to receive. So it's important that any like a deposit account, especially your IRAs, your life insurance policies, that you have beneficiaries assigned. If not, then that's what will cause a family then have to go to probate in order to get access to those assets. So again, we would recommend doing a periodic review of the beneficiaries that you have listed to make sure that that if changes need to be made, they get made before an event takes place, like someone passing away. On the next slide, we're going to go over just some accounts to consider adding beneficiaries to. So again, an IRA, annuities, life insurance policies, certificates, health savings accounts, checking accounts, saving accounts, money market accounts, and mutual funds. So one thing that I want to go back to and go over or to expound upon what Lauren said about joint owned accounts. So again, remember that a joint owned account can have a beneficiary, but if the joint owner is still living, they are the ones who are going to benefit and get the funds. But if both members pass away or account holders pass away, then a beneficiary would be the person who benefits from the funds. So it's important, just because there are 2 owners doesn't mean you shouldn't have a beneficiary. You actually should, just to make sure someone is designated to benefit by those accounts.
As we're wrapping up and getting ready for our Q&A, which Kelly will facilitate, we wanted to make sure that we gave access to our legal partner at Wood and Lamping, Ed Bender. There's a lot of could be legal questions. Some of the questions that might be asked, I might actually refer either back to Ed or to the attorney that you are working with, or your estate planning attorney already. So we wanted to give his information up there as well. And on the next slide, you will find our information. So it has been an absolute pleasure to spend the afternoon with you. I look forward to hearing some of these fantastic questions I know you're going to ask, but please feel free to reach out to Bridget and myself. These are complicated matters, complicated things to think about, and we want to be a resource for you. We want to be here for you. So if there's absolutely anything that comes out after these questions, please feel free to reach out to Bridget and myself. And now I'm going to pass it back to Kelly to do some question facilitation.
All right, wonderful. Thank you, Lauren. Thank you to both you and Bridget for taking us through that awesome content. I know it's super important, and that was very detailed. So I appreciate you guys being here and taking us through that. For everyone on today's webinar, as Lauren mentioned, we're going to open it up to the Q&A session. So if you have any questions you would like to ask today, please submit those using the questions feature. And we will get to as many as we can in today's time. So with that, I know I see a couple in the chat already, so let's go ahead and get started with one of those. They are saying, I live in South Carolina. What are the challenges dealing with someone living in California other than the distance?
I think that really depends, and I'm not entirely familiar with either of those state laws, but oftentimes powers of attorney have limitations on who can be power of attorney. Sometimes there is, in fact, sometimes it does have to be a person in the same state, and that's really the same for an executor as well. We have seen in the past where we've had a member who's passed away and their son tried to become executor but does not live in the state of Ohio. So there can definitely be some state law challenges with that, you know, so I would absolutely kind of consult your estate attorney or look at those state laws to see what that means for both power of attorney and executor.
Thank you. There's quite a few questions coming into the chat. Let's go ahead and move on to the next one. It's stating, are there limitations on who are beneficiaries for business accounts?
So most of the time, at least on our side, we, as a financial institution, we would not list beneficiaries on a business account. There are ways to plan for what would happen if you are a business owner and you do pass away or something happens, but that's not in the form of a beneficiary. Beneficiary is more of a consumer term and not a business term. So most of the time, a lot of those contingency plans when it comes to businesses are written in the operating agreement.
This next question is also from the chat. What is a living will? Are you only carrying out wishes while a person is still living?
So basically a living will is a document that can continue to be amended and changed. And that is actually the document that if you passed away you would take to the probate court. What would allow someone to act on your behalf or something like that while you're living is actually that power of attorney, not that will documentation.
This next question comes from the chat as well. Can you retitle a financed car to an irrevocable trust?
Yes, any asset, whether it be a bank account or a titled asset, can be an asset of the trust. There can absolutely be vehicles and everything of that nature titled to the trust itself.
All right, this one is from the chat as well. When are the times you recommend setting up a trust as you were discussing earlier?
That's going to be more of an estate planning attorney question. And the reason that I say that is because there's a lot of benefits to trusts, and you know, we've been talking a lot about that today, but there are also some implications of trusts. And so I would recommend consulting with your estate planning attorney or contacting Ed, who I'll have Kelly put his slide back up with his information, because there's a lot to consider when making a trust and if that makes the most sense for you in your current position.
This next question, do you need an attorney to retitle a deed to a trust or can you do it yourself?
My recommendation is that anything that is being retitled to the trust, you would want to consult your attorney first to create the initial trust document, but even if that is initially written, to make sure that the language in it is applicable and is still what it needs to be, to also add in those titled assets to the trust.
Thank you. This next question, we had some questions pre-submitted, so when people registered, they had asked some questions ahead of time. I want to make sure we get to some of those as well. This first question is saying, I have a brother who has been on disability for the last 40 years and therefore owns practically nothing worth any value. So other than the funeral, what else is there to plan for?
I think it's important in any situation to consider personal possessions, which I know Bridget talked a lot about what that might look like. So to consider personal possessions, and then if there are any assets at all, such as a home, a vehicle, even if we assume they might not be of a lot of value, there still might be some assets that have value that we need to consider, and then also to again consider any bank accounts. So it would really be those three things: personal possessions, titled assets that individual might own, and bank account.
Thank you. This next question was also pre-submitted. How does the executor handle the bills and any debt of the family members?
Basically, as we talked about, the estate is comprised of the assets and the debts of an individual when they pass away. So all of that needs to be compiled. So there's information that needs to be provided if it is in fact an executor situation going through the probate court. There are statements that need to be provided, and basically proving the value of all of the assets and the potential value of all of the debts, and then working with the court, you would settle what that looks like and assist the court in paying off the debts, and then if and when there's assets left, distributing those assets either based on the will, or if there's no will, based on the probate laws in the state where the deceased individual lived.
Let's see, our next question was also pre-submitted. How can I pass on a home and contents to children without going to probate?
In terms of it really just is going to depend on what's right in your situation, but some of those recommendations are what we talked about today, which would include titling on the accounts, such as either making sure there's joint owners, making sure there's beneficiaries, making sure those things are in line, or potentially speaking with an estate attorney to determine if adding assets to a trust is the right thing to do as far as estate planning.
This next question just came in from the chat. Who gets a copy of the will and how soon after death?
So the will itself would actually need to go just to the probate court. So most financial institutions, I will actually probably say all financial institutions, cannot accept a will, because the will needs to be validated and authenticated by the probate court. So as a financial institution, we can only accept the documents that come from that will validation in the court. So the will itself would be taken to the probate court in the county where the deceased individual lived, and then if you're named the executor, you'll get called what's called probate court paperwork, and you would bring that probate court paperwork naming you as the executor to any financial institution.
This next question was pre-submitted. Does the credit union have any services or documents you can share to help move families forward or along in this process?
Yeah, absolutely. So of course we have our legal partner, Ed Bender, who I've talked about quite a bit today. But secondarily, and I believe Kelly has has added it into the handouts, and I'll let her confirm that. But we do have a digital guide on our website, and it goes through a lot of definitions, a lot of content, a lot of information. It is quite lengthy, so be patient there and feel free to ask Bridget and myself any questions as you're reading it. But it is a digital guide on our website talking about handling a deceased loved one's accounts and the different steps that might be associated.
Yes, and I will confirm, as Lauren mentioned, that guide can be found in the handout section. And I also put it in the chat where it's a link. So if you want to click on that and just go to where it is on the website directly, feel free to view it that way as well. This next question was also pre-submitted. Should a loved one not complete paperwork to assign power of attorney and such before they pass? What is the process if no determination is made?
So the one thing to keep in mind here is that the power of attorney itself is only valid while that person is living. So once they pass, that power of attorney is basically null and void. So what would then take place, and Lauren has already stated this, is that there would be an executor named by probate court, and that person then would be responsible for handling matters for the person who has passed away. Now, if a person doesn't have a will that would have been taken to probate court to be validated and authenticated, then someone would have to apply to become the executor of the decedent's estate.
Thank you. We have time for a couple more questions. This one is asking, what happens if a named beneficiary passes before the owner?
So the owner would just need to update their beneficiary. If the owner and the beneficiary are deceased, then the asset would go to the estate of the decedent.
Thank you. This next question, does having a trust help one avoid probate? Are there things that always go through probate?
So yes, having a trust would definitely help to avoid going to probate. And as long as things are titled properly, then probate wouldn't be needed. So if you think in terms of a deposit account, so a checking account that is a sole owner and there's no beneficiary, then unfortunately in that case, then probate would be needed in order to resolve that account.
And then I think this might be our last question. As a trustee, how are trusts handled after a loved one passes? Will I need to hire a lawyer for anything, or can I handle it without one?
So when Lauren was going over trust, she covered this in that section. So if the grantor is basically, again, the owner of that trust, and could also be a trustee. So let's say the grantor is a trustee and then they pass away. They could have a successor trustee named in that trust who would then be responsible for executing the trust and taking control of the assets. And just to reiterate what Lauren said, it's recommended to probably retain an estate attorney to make sure that all the assets in that trust get distributed properly and handled properly.
Thank you. And then I was mistaken. There is one more question that came in through the chat, so we'll go ahead and end with this one. Does the financial power of attorney cease at the time of death?
Yes, it does. So power of attorney is only going to be valid when that principal or the person who initially executes the power of attorney, as long as they're still living. Once that person passes away, unfortunately, that power of attorney document is null and void.
All right, well, that's going to conclude our Q&A session for today. Thank you again to Lauren and Bridget for taking us through today's content and being here to answer all of these wonderful questions. If you have anything that comes up after Lauren and Bridget's contact information is up on the screen, so don't hesitate to reach out. They'd be happy to answer anything that you think of after today's webinar as well. And with that, thank you all so much for joining us today. We hope you learned a lot of information. If you have any questions, again, feel free to reach out to Lauren or Bridget, or you can reach out to events@gecreditunion.org, and I will get your questions passed along to the appropriate person. But once again, thank you for joining us and have a great rest of your day.